He proposes, she accepts, and the date for marriage is set. The couple sits down to discuss the prenuptial agreement. Still fresh from the glow of romance, is it appropriate to think about the demise of the marriage? Unfortunately, approximately 1/3 of all first marriages and nearly 1/2 of all second and third marriages will end in divorce, so a prenuptial agreement may not only be practical, but necessary. This video is designed to provide you with some basic information to help you decide whether a prenuptial agreement is right for you and your future spouse. A prenuptial agreement is a private agreement between two people who intend to marry. The agreement sets out how the couple's assets and debts will be distributed in the event they divorce or one of them dies. Generally, the couple is given substantial leeway to divide their property as they see fit. You are probably asking yourself, why would someone choose to use a prenuptial agreement? Well, because without one, your assets will be divided according to your state's laws. With a prenuptial agreement, you are the one to choose how your assets will be divided. There are 4 basic rules that you should know when drafting your prenuptial agreement. First, you and your partner must be completely honest about your assets and debts. If either of you hides something or lies to protect your interests, a judge can discard the agreement. Second, the prenuptial agreement must be signed significantly in advance of the wedding to avoid the appearance of impropriety or coercion. Third, each of you should be represented by separate and independent legal counsel during the negotiation. Finally, the prenuptial agreement must be fair and reasonable. Now that we covered the basics, let's cover a few other important issues. Dealing with the financial support of children can be one of the most difficult provisions when preparing your agreement. It's important that you don't attempt to waive child support payments or put strict limitations on providing it. Courts don't look kindly on efforts to circumscribe the rights of children, and attempts to do this will likely not be enforced. In these cases, the court itself may investigate what distributions and outcomes will be in the best interests of the child. You also have the option of including so-called lifestyle clauses. This may include any non-financial understanding that you wish to document before the marriage. You should note that the courts may not enforce what they believe to be frivolous provisions. For example, a provision that requires that one spouse not gain weight will probably be ignored. On the other hand, an agreement between the parties that their current or future children be raised in a certain religion may be considered. The key factor that will be considered by the courts is whether or not the parties have created a serious and meaningful clause. Now you know the basics and have taken the first step to creating a valid and enforceable prenuptial agreement. Additional information and attorney-prepared prenuptial agreements for every state can be found at www.findlegalforms.com. Good luck and congratulations on your marriage.